Hi guys, this is Ryan Meyer, EDU 503, Week 7, Chapter 8. For this week, I chose to examine the case of Franklin versus Gwinnett County Public Schools. The case involves Christine Franklin, the petitioner, who was a student at North Gwinnett High School from 1985 to 1989. Franklin had filed a complaint under Title IX that she had been sexually harassed by Andrew Hill, who was a teacher and sports coach at the school. This case is monumental because this is the first case that the Supreme Court held that monetary damages could be awarded in Title IX cases. The petitioner claimed that school officials were aware of allegations. However, in this particular case, she claims that they took no action. And this particular case is also interesting because of the accused teacher. He ended up agreeing to resign from his positions if all charges were dropped. And then at this point, the school closes its investigation. So, in this action, the district court dismissed the complaint on the ground that Title IX does not authorize an award of damages, and the Court of Appeals affirmed this decision. However, where legal rights have been invaded, a federal statute provides for the general right to sue for invasion, and federal courts may use any available remedy to make good the wrong done. At this point, the case was pushed all the way to the Supreme Court in 1991. When considering the issue of remedies, the court followed the traditional presumption that, in quotes, absent clear direction to the contrary by Congress, the federal courts have the power to award any appropriate relief in a cognizable cause of action brought pursuant to a federal statute. And the court found no evidence that Congress intended to abandon the traditional presumption when it passed Title IX. The justices dismissed the notion that allowing monetary damages would extend the federal court's power into an area that belonged to the executive and legislative branches. The court further rejected the argument that because Title IX was enacted pursuant to the spending clause of the U.S. Constitution, monetary awards were not permitted. Referencing the court case of Pennhurst State School and Hospital versus Halderman of 1981, the court had limited remedies under a spending clause statute, but that case had involved unintentional violations. The violation in this particular case was intentional and thus did not fall under the earlier ruling. Although some maintain that Title IX allowed only for back pay or in order that the violation end, the court found such remedies were largely useless to students. In this particular case, the student had no claim to back pay, and she was no longer at the school. In addition to that, the accused teacher, Andrew Hill, had already resigned. The court then ruled that monetary damages are available in cases involving violations of Title IX, and the 11th Circuit's decision was reversed, and the case was remanded. Later, this particular case was settled out of court, and the settlement details were not disclosed. This case is particularly important to athletic administrators and all stakeholders in a school system because as adults in a school system, we must ensure that we must ensure due process when allegations of this type of magnitude are brought to our attention. Anything regarding Title IX, sexual harassment, there are very strict steps and very strict guidelines you must follow. And it's very important that when something like this is brought up to an administrator's attention, that it is communicated to the correct channels, and that everything is done to ensure a proper investigation takes place. We see in this case that was not done, and you can kind of see that the reputation of this school district probably dropped a little bit after this case because of the way that the administrators at the school handled it, and that's something that you don't want to attract to your athletic program. And the last thing that I would say is any cases of wrongdoing, whether that are great magnitude or even just a small, allegation of wrongdoing within an athletic program, you must make sure that you cover all your bases because things that might start off small might end up being larger issues if you continue to let them go. And coaches, trainers, whoever you might be hiring might feel like there's a sense of leeway that they have. And so you must make sure that you communicate and you investigate any sort of accusations to the full extent to ensure that your athletic program remains in good light.